Today, the head of IDAC is cornered, and she is apologizing. Advocate Andrea Johnson came to this commission to defend an investigation that put a woman in handcuffs. She leaves conceding it may have no factual basis at all. The commission has opened the file in front of her: a degree in industrial engineering, a diploma in mechatronics, 12 certificates. And then Commissioner Khumalo says this: "Before I saw these files, the picture painted in my head was that crime intelligence appointed a receptionist from BMW. Then it became clear to me that this person is not just qualified, her qualification exceeds the requirements." Her answer: "In terms of the documents that I now have sight of, that is incorrect. She does have the qualification." Asked to withdraw the words token appointment, she goes further: "I would have to apologize." And it doesn't stop there. A prosecution memo built on documents she admits she never read. A docket opened before she authorized the investigation. A summons issued in February, months before her own authorization. And a commissioner telling her to her face that the power may have been exercised for an ulterior purpose. Hit like, subscribe, and turn on that bell. Let's go inside.
Authorized an investigation at the earliest, the 1st of June. It doesn't give us the actual date, but best case scenario is that it's the 1st of June, 2025, when a docket is opened.
I take that.
And your authorization to investigate is the 30th of May.
Correct.
So they're already deciding to open a criminal case before proper investigations in terms of Section 28(1). Do you see that? Could have been later in the month of June.
But I do see it's in the month of June.
It's in the month of June.
Yes, ma'am.
And remember, we are chasing the 26th of June, which is the arrest date. And we're trying to understand what happened when, post the 30th of May. Staying on that page, at the bottom of that page is a date, 2025-01-06, bottom left corner.
I see that.
Now, Colonel Padiache explained that this was a preamble, this preamble to the statement and the statement were obtained on the 6th of January 2025.
Okay.
That's his explanation, because I couldn't understand why the docket has got a June date, as we have determined, but the statement seems to be taken in January. He had an explanation for that they open the docket, or they take the statement in terms of this document and will subsequently open an official criminal docket later. That's the explanation as I understood it. And I accept it. I've got nothing to countenance it. So my issue really is, on the 6th of June 2025, already we are into criminal investigation mode. And this is very early during what ought to have been the 2813 preliminary investigation process to help you determine whether to institute a formal investigation in terms of Section 28(1)(a). Do you accept that?
I'm with you. I accept it.
And that is where then my challenge lies with this 2813 preliminary investigation and the authorization for the actual investigation. And I suggest that, I'll say the investigators in this case, abuse the Section 2813 preliminary investigation to conduct a full-blown investigation before you so authorize them. They've gone so far as to obtain documents from SAPS to prepare an A1 statement in January.
As I indicated earlier, Council, The 2813, while it is a
happens on the back of a decision for a preliminary investigation. My difficulty with that is that full-blown investigation is used to show up an incompetent referral, Section 27, if that's what happened. Because what you had is, you had this wholly inadequate Section 27 affidavit, which on its terms does not make a case that triggers your jurisdiction. You then authorize, as you say you're entitled to do, or you have the power to do, you then authorize a preliminary investigation. And that's where you collect all of this evidence. But you use that to show up a poor referral. So again, that's not the purpose of your Section 2813 preliminary investigation. It's not to assist what should have been kicked out or not accepted by you because it didn't trigger your jurisdiction. It's not to use that process, because if that's what you are doing, then you are using your Section 2813 process for an unintended purpose. Its purpose is not to fix Mr. Adams's poor Section 27.
correct.
It cannot be. So if your explanation is correct, that's exactly what happened, then we are again in that territory where, in fact, the Section 2813 was used as a pretext to make up a case that Mr. Adams should have pleaded or should have stated in his founding affidavit, and so your people would have acted improperly. They did that which the law doesn't allow to use that process for, which is the point that Mr. Law was making, that you authorize a preliminary investigation, but that preliminary investigation, in fact, is used to conduct a full-blown investigation. Your explanation of it proves exactly that they use the pretext of your authorization to assist, make a case that places Mr. Adams's complaint into your jurisdiction when, in fact, from the get-go, it didn't fall within your jurisdiction, at least not in Section 27. Do you accept that, if that's what happened?
I accept that.
Okay, thank you.
Thank you, Commissioners. The same instruction note that Commissioner Khumalo referred you to.
That is correct.
So you do know that instruction note?
I didn't see the instruction. I know of this instruction because I got this from the briefing from the team in order to prepare this memorandum.
No, please say that again.
So when I prepared the prosecution memo, it is as a result of a briefing I get from the team. So the charges against the suspects were presented to me by the team. And so part of the charges and part of the case is as a result of the feedback I got from the team. So I would have got from the prosecution a memo, a draft memo, upon which I look at it and then compile my referral to the DPP. But I didn't see the actual instruction as Commissioner Khumalo had shown it to me today. I didn't look at that instruction.
So the upshot of what you are saying is that in your prosecution memo, you referred to documents you had not seen.
I did not see this document, no. It is as a result of a briefing by the team a memo that I would have got.
I accept that there was a briefing. I'm saying the long and short of it is that in this memo, you referred to documents you had not seen.
Correct, sir.
So you did not even know that the Section 9 you are quoting, in fact, says what you say in your memo. Because if you had not seen it, you could not satisfy yourself that it says what you have quoted in paragraph 11.
Section 7. Yes, that's correct. It would have been as a result of the briefing, not of me seeing the yes. document.
So you did not satisfy yourself that what you are quoting in your paragraph 11 is in fact what the instruction says?
No, I relied on my prosecuting team and my investigators.
And then you proceed at paragraph 12 to state, same document, evidence collected proves that accused 1 to 6 contravened the provisions of the above quoted section to benefit accused 7 without just or reasonable cause.
Yes. And that I would have got from the briefing. It's a briefing that they would have given me and indicated, Chair and Commissioners, how each one is allegedly implicated.
What if they are wrong? You are triggering a prosecution. What if they are wholly wrong? Your investigators and whoever it is you rely on.
My prosecutors and investigators.
What if they are wholly wrong? Because nowhere in this document do you say, I come to understand or I'm made to understand. You're making definitive assertions here, suggesting that you are familiar with the prescripts, you are familiar with the evidence that has been collected, and you confirm that accused 1 to 6 have contravened the prescript. How is that not misleading, perhaps, to the DPP?
No, because I did get a briefing and I have no reason to believe that the prosecutors would have briefed me incorrectly.
But you are making assertions to the DPP on matters you know nothing about.
No, I know.
And that's by your hand.
Sorry, I interrupted you.
I was saying, and this is by your hand. So the DPP reads that as she should, to understand that the head of IDAC has satisfied herself, because that's what triggers her response at 3255.
Correct, and I'm saying that I satisfied myself from the briefing that I received from my team.
Okay, now,
to me by the commissioners and the manner in which we engaged.
I know Commissioner Khumalo wants to pose a question, but before he does so, may I correct you? I understood you to say you're not vested with oversight over those investigations. That's got to be wrong. You are the head.
Yes, may I explain?
Absolutely.
On the 19th of June, I approached the national director and I did ask, I hope Advocate Maga, you have now provided, because I think Commissioner Baloy did indicate that we hear what you say, but where's the proof? On the 19th of June, I approached the national director on my own, and I indicated to him that it might be best for the interests of IDAC and the NPA that I be removed from the oversight of these matters. The basis for that, commissioners and council, was that on the day prior, there was the media briefing by General Nhlanhla Mkhwanazi. What that brought to bear for myself is that for as long as I am in these matters, the matters themselves are not seen. The focus becomes the ID, or the focus becomes Andrea Johnson. That is not in the public interest. That is not in the interest of justice. I had that open conversation with the national director on the 19th. The national director asked me if I am sure, and I said yes, because the matters, as well as the NPA and IDAC, have to come first.
Then, if I understand, the power of oversight is bestowed upon you by the statute.
That is correct.
So you're suggesting, pursuant to a request you made, you were stripped of that power insofar as matters relating to crime intelligence are concerned. Is that what you're saying? And to whom has the power then shifted?
If I can just go here on the appointments, I might have to look as well, commissioners, at in detail the if there are, and I assume there would be, standing orders with regards to vetting and make a determination on those matters and submit them through to the office of the NDPP.
Standing orders sounds very police-like. You meant national instructions, I think.
Sorry, national instructions, sorry.
Can I just ask the question? Before this Mukwele matter, or apart from this Mukwele matter, has IDAC investigated any employment, appointment, recruitment issues ever?
Commissioner Balawi, no, not that I'm aware of, no.
Thank you.
I really hope Commissioner Khumalo hasn't forgotten his questions. I know, took a bit of a detour, my apologies.
It's not a detour because we national instruction.
I
that
accept
fair?
that.
Is that fair?
That is fair.
Yes. Now, let's look at the suitable qualification. What suitable qualification do you say Ms. Mukwele did not have when she was appointed to this role? What is that suitable qualification that you say she did not have?
I would have to have sight of the, I can't tell you off my head, I'd have to have sight of the advert.
Go to file 2, page 178.
File 2. Sorry.
Can you please flight it?
And because Commissioner Khumalo seems to know all the pages here.
No, it's file 2, page 178.
I am there.
Yes.
I
So
would have to
those
read
are,
it.
if you look at item 3.2.
Yes,
on
I
that
have gone
page.
through that one.
So that is the position in question.
Yes.
Do you see that in bullet 1, it requires that the person must have at least a 3-year degree or diploma?
In policing, public administration.
Yes. And then it
management
says
law,
in
etc.
policing or public administration or criminology or intelligence or electrical or mechanical engineering. Do you see that? Or did IDAC stop at policing and say?
No, I'm reading as
Yes.
you, yes. And I don't know her qualifications, but the fact that you point me to that means they must be there.
Stop there, Advocate Johnson. You don't know her qualifications.
I know she has, it was called mechatronics.
Do you know what her qualifications are?
Not all her qualifications, no.
So why do you make a statement under oath to say she's not suitable for this position if you don't know what her qualifications are? Why do you make a statement to this commission to say the big picture will show that she doesn't have qualifications? Can I ask that they be flighted so that we can look at them? Can we go to 270 on the same file? Are you there?
Yes.
So that's a degree in engineering, industrial engineering. Do you see that?
I see that.
So already she meets the qualification. Now go to the next page on 271.
I see that.
Are you there?
I am there.
Now that's a diploma in mecha, not mega, mechatronics. Now, what is the relevance of that? That is the core description of this role. If you go back to the advert on 176, you will see that the core functions, what crime intelligence was looking for, is exactly this qualification, because the description of the role tells you that they want somebody who's qualified in mechanics and electronics and all of those. Do you see those?
I see that, Commissioner.
Yes. Now, from 270, I don't want to show her metric certificate.
No,
it's not
yes.
fair to Ms. Mukwele, but it's on 272. Please don't flight it. It's quite clear that this is somebody who is very bright. I must say this to you. Before I saw these files, the picture painted in my head was that crime intelligence appointed a receptionist from BMW. That's the picture I had in my head. Until I saw these files, then it became clear to me that this person is not just qualified, but her qualification exceeds the requirements. Now, from 273, which we can flight, it's about 12 certificates that I've counted, because one of the requirements was that you must be familiar with computers, you must be familiar with finance, you must be familiar with how the public service works. So there's a series of them. I counted about 12. Cybersecurity being one of them on page 281. There's about 12. We don't have to look at all 12 of them, otherwise
I'm
it
just
will
quickly
take
browsing.
the whole day. Now, having seen all of this, do you stand by what is stated in 25.1 of your affidavit that she does not have the suitable qualifications?
So she must have at least 3 years, an applicable postgraduate qualification, relevant in middle management, learning programs, must have a minimum period of 3 years appropriate managerial experience in the field of the post. For me, the only one, I'm not disputing what you're asking me. I just want to
Are you saying she's not bilingual and she doesn't have a driver's license?
No, no.
Because those are some
No.
of the requirements.
No.
Do you want to dispute those?
No, must have
So
a minimum.
what do you say? What is the qualification that you say in 25.1 of your affidavit that she doesn't have? What is
Must
that
have a minimum
qualification?
period of 3 years appropriate managerial experience in the field of the post.
Is that a qualification?
No.
Experience is a qualification.
No, it was just a requirement.
Yes. Now,
Yes.
your
In terms of-
affidavit says she does not have the
In
qualifications.
terms of the documents that I now have sight of, that is incorrect.
It is incorrect what is stated in your
It
affidavit.
is incorrect.
She does have the
She
qualifications.
does have the qualification.
Now, what your investigators have done in their affidavit to the court, they have said, Ms. Mukwele does not have 7 years senior management experience, and therefore she does not qualify. Now, show me on 179,
It doesn't say so.
where it says you need 7 years senior management experience.
It does not say so in
And
this.
that is the basis for IDAC targeting this female person and subjecting her to criminal proceedings and humiliation. What the advert says is that you must have appropriate management experience. Where does one find a definition of appropriate management experience? Where does one find that? It's in the national instruction. It's in the definition section of the national instruction. And this is what the national instruction says. You must have experience above the level of a supervisor. That's all that was required. If Ms. Mukwele met those requirements, then she complied with the minimum requirements according to the advert. In her application for this position, she lists all those. She goes further and she says, I'm studying for my MBA as a token appointment. It's an unfair statement to make, having not seen her CV, having not seen her qualifications. Can you please, in this commission, withdraw the statement that her appointment is a token appointment? It is an insulting thing to say.
I would have to go further than to withdraw. I would have to apologize that that statement was made.
Because it's one thing to say an appointment is irregular.
Yes.
It's quite another to say it's a token appointment.
Yes. I base it on what I was given, but I accept, having gone through this file, that the word unsuitable is unsuitable, and that the word token is wholly inappropriate.
Sorry to interrupt you.
The affidavit, even allowing for your explanation that you didn't look at the documents, so you never saw this advert. You relied on a briefing from your investigators and had no reason to doubt them, even allowing for that. The difficulty that I have with your 25.1 is that at the time that you prepare this affidavit,
Commissioner.
is that at the time that you prepare the affidavit for the commission, you now have the full set of documents. You have the docket, as you prepare, and I must again assume that you prepped for this. You didn't rely on briefings when you came here. You looked at the documents, what they say, how did we get to those decisions, what were we relying on, because you know that you're going to be asked questions about this. And if that's what you did, I have a difficulty that you still represent what you state in 25.1. When your dockets, when your documents, all your documents that you requested were collected by your investigators are now all before you, you are coming to the commission, and you still repeat the statement in 25.1, which as Commissioner Khumalo has shown you, it's not supported by the documents that are in your own dockets. And it leads me to one of two possibilities, that as you come to the commission, you come prepared to continue a narrative that is not based on any evidence that was before you, properly placed before you, and underlined properly placed before you, for purposes of your decision then, but also for purposes of your preparation here. Notwithstanding that, you are prepared to continue that narrative. The alternative is that you did not do the necessary preparation to be able to give us full comprehensive. And you said, well, I didn't remember it, but we know there's a record of it. Here again, there's been this repetition of a narrative until you are probed, you make the concession, and yet some of the things, in my view, should not even have required you to be probed. You know, you should have come in and said to us, I've looked at this, and either you did not look at this stuff in preparation for coming here, or in my view, you looked at it, but you were going to continue the narrative because that's already what you have said on paper and in other fora, and that's why you stick to that version, because you cannot change it. I struggle with that, and I struggle with that, as I say, because not only because you're head of institution, but also you're a lawyer with obligations to forum like ours, with a full understanding of what an oath means and the consequence of saying things under oath that you had no reasonable basis to believe. I ask in that way, and it is a matter of concern for me. that you have continued this way and concessions have had to be forced out, well, forced out of you, forced in quotes, but had to be extracted from you without you volunteering them upfront. I don't know if you want to.
So after you granted your authorizations, and that would have been in May, 30th, on 30th May 2025, you recall that?
I recall that.
So now, at file 3, page 936, is a summons issued on the 6th of February 2025. And if you go to 937, it states, under details of the matter or other information, this investigation pertains to manipulation of security vetting processes which resulted in the unlawful issuing of security clearances in favor of personnel within the division, crime intelligence of the South African South African Police Service. This is in February. So it's not informed by any investigation. At this juncture, the assumption was that it's informed by the Section 27. Now you have just testified that no, the issue of vetting and security clearances in respect of those persons listed at 938 arose after the preliminary investigation and not from the referral itself.
Yes.
That's what you explained. So now, are you able to explain why it is your investigators in February already? Remember, you are still to authorize a Section 28 investigation on the 30th of May. In February of 2025, if you go to 938, and therefore she will be looting state funds to pay, she'll be colluding, I correct myself, I don't know with who with, but to loot state funds and purchase properties. What in those files should we look out for to support the conclusion that you draw, the fear that you express at 25.3?
I'll just have to be given an opportunity to go back and to look into the evidence.
No, you must have had it. For you to submit on oath, you confirmed the correctness of this statement when we started. Correct. So you must have an idea, and I suggest that perhaps you start sharing it with us. Might not be firmed up. When you return, you will give us the full now facts, chapter and verse. But for now, when you wrote 25.3 in relation specifically to Mrs. Mukwele, on what basis did you conclude that she was going to collude in the looting of state funds with whomsoever?
Commissioners, I ask for a moment.
Yes, please.
Are you thinking of a specific document, perhaps?
I'm just perusing.
I'm not rushing you, but
Yes, I'm trying to peruse through the charges available under circumstances where she would not have made them available.
But how do you know that?
That was because of that environment, and because of the fact that from previous matters, not in IDAC, that is how funds were looted. Out of accounts where the funds are within a covert environment. So motivations would be put in for access of that money.
You are being,
Without-
if I may come
sorry.
in, no. No. You are being grossly unfair to Mrs. Mukweli. Now you are attributing conduct of persons she has no knowledge of to her in the future, no how. And you are saying you accept that she may be required to access those funds in the course of execution of her job. But the impression you create here at this 25.3 is that she would do so to loot. So that apology that I think you sought to extend to her, you might as well take it back. You are seriously impugning her credibility, and we're trying to find the basis on which you say she was going to loot.
I hear you. That is not the intention. I'm trying to give an example of how I find that space. And,
You see,
sorry,
no, you may continue if correct.
Yes.
Yeah, because you have no basis to think that she is different, and that therefore this would apply only to her. So anybody,
in that position.
if what you say is logical, anybody would also be susceptible to this impropriety.
I accept that, Chair.
Thank you.
Advocate Johnson, in June 2025, this is exactly the charge that was presented, even in the draft charge sheet to justify Ms. Mukwele's arrest. It's exactly this. So she has gone through all of this over a period of a year. It's not new that for the first time today you are making this allegation. The memos, the draft charge sheet, and all the documents, this was exactly the issue. And I say this for my part, I have no sympathy for people who loot state funds. And if there are people, whether they are generals or not, who are involved in the looting of the secret account or whatever it is, I have zero sympathy for them. But this case, as Commissioner Baloyi said yesterday, is a serious abuse of power by IDAC to target a civilian. And that's what I have a problem with. My sympathy for her is a bit different to the generals, because if they did what they did, the law must take its course. But we must draw the line where organs that are supposed to protect the public and, work for the benefit of the public are used in this manner to unfairly target civilians. That is just not right.
I understand, hence I made the apology earlier. Yeah. It does not detract from the
view. Where does this all come from, right? And on the face of it, so far, between you and Colonel Pareachi, you haven't given a satisfactory explanation, I must say. And I accept that you're still going to give us documents, the A1 statements, and maybe we'll see from there what were the facts that led to this allegation in 25.3, but also that led to the charge itself. Absent that, if you do not have documents that show the facts on which this charge or this 25.3 is founded, if you don't have any such documents, then this was an arbitrary decision not based on any facts, and because of it being an arbitrary decision, it is a use of investigative powers for ulterior purposes. If it is not explained satisfactorily for ulterior purposes, then we have to ask the question, what was the purpose? I hope you understand, what I'm saying, yeah. So we still have to answer that question.
Correct.
And hopefully your statements will the A1 statements will put us at peace, that there was a basis for that. But as matters stand, I must say, from where I'm sitting, that with everything that is before us, and until we get something else, then the exercise of the power to investigate and to charge an offense of gratification under PRECA was exercised without proper consideration, without facts placed properly, and I underline properly, placed before you for this, and the prosecutor and all the people that I've listed, to formulate that charge. On the face of it, the power that you have, all of you that I've listed, you exercise it for an ulterior purpose, and hopefully by the end of the evidence of the IDAC witnesses.
From their unlawful acts. I think that follows on the conversation we have just had.
And that falls away.
Ma'am?
That falls away in terms of the appointment.
What falls away?
What I'm saying is the picture that has emerged is that the appointment and installation of certain persons, and we agreed that in that paragraph, it refers to Brigadier Mokwele.
Yes.
That the part of the appointment falls away, that those first two lines fall away, and that short of there being documents to prove the rest of the paragraph, then that falls away.
Okay.
But that we must have that evidence, because those assertions cannot not be based on evidence. And
So
that is what I'm
the
saying.
entire paragraph falls away.
Then that entire paragraph would fall away if I'm unable to find in the Adams affidavits that the investigators say they obtained per docket, Commissioner Khumalo.
It goes further. Even following IDAC's own investigation in two parts, the preliminary and the subsequent one, there is simply no basis for what is stated in that paragraph. No.
About appointments, suitability of appointments, the placement of individuals, and what that placement would have done is what these paragraphs allude to. But when you go back to the discussion we have had about the policies and the prescripts, it becomes clear that the persons that we thought had been put in certain positions for certain purposes, leaving out the gratification portion, which one must still look at, then that in fact is then not the case.
Then let's look at 27. What about the capture of system and processes for private interest by General Khumalo? Does that remain? Is there evidence that General Khumalo has captured systems and processes for private interest?
That would fall away in terms of the discussion we've had, because a lot of it, in the main, revolved around, and I hate to do this, Commissioner Khumalo, it does revolve around the appointment of Brigadier Mokwele, which we have now dealt with. That was the systems and the capture. Those were the allegations.
So then it would be fair to say we hold these issues in abeyance until you have checked your investigation files and you see if, okay.
Absolutely.
I'm happy to do that.
I must check the evidence.
Yes.